All right, you ready?
Yes, sir.
I appreciate it. Thank you. All right, good morning, everyone. Today's July 20th, 2021. This is the Magistrate Court of Clayton County. Judge Knight's presiding this morning's first appearance calendar. And today for first appearance, I'm going to be informing you of your charge or charges that you have against you, your next court date, which is your preliminary hearing date, your bond, if you're entitled to a bond, appoint an attorney to represent you if you qualify based on your application that you completed, and most importantly, to inform you of your constitutional rights. So each of you have these constitutional rights that do not go away. No one can take them away from you. You have the presumption of innocence. The state, which is the district attorney for felonies, or the solicitor general for misdemeanors, have to prove this charge or these charges against you beyond a reasonable doubt. They have that burden alone. You don't have any burden. You have the right to a speedy and public trial by jury. You have the right to see, hear, and cross-examine any witnesses that the state can call to testify against you at that trial. You have the right to subpoena witnesses on your own behalf and to testify if you choose to do so. Of course, you don't have to testify. You have a Fifth Amendment right against any self-incrimination or against making any statements on your own behalf, but you can if you choose to do so. Also, you have the right to an attorney, and an attorney can represent you at any stage of these charges or charge against you. So I want to talk about a few things. One of those things is that you can get a bond today. Keep in mind, this is magistrate court, and as a magistrate court judge by law, I cannot give a bond on certain offenses. I can't do it by law. A superior court judge has to do it. So if you don't get a bond today, it's not because of anything other than I can't do it by law. Additionally, it can be based on your criminal history. If you're on parole or probation, that can prohibit you from getting a bond. Also, based on the nature of the offense, as well as other conditions such as being a flight risk or criminal history, those things can play a role in the bond and the amount of bond. So everyone is different. Two people might have the same charge, but that doesn't mean those same two people will get the same bond. All right, so there's conditions that are reviewed in order to give bond, or the law may prohibit a bond. So keep that in mind. If you don't get a bond, that doesn't mean you'll never get a bond. It just means you're not getting a bond today. You'll have a bond hearing, or can have a bond hearing, or your lawyer can speak with the district attorney and can come up with a consent agreement for bond, and you can get a bond at another time. All right, so if I tell you that there is a special condition of bond, that means you can't go somewhere or you can't contact someone. So if I say don't go to 123 Main Street, you can't go to 123 Main Street. If I say don't contact Joe Smith, you can't contact Joe Smith. Failure to comply with the special conditions can result in additional criminal charges such as influencing a witness or aggravated stalking. Also, if the person who's the subject of the special condition of bond wishes to post your bond, they cannot. So if Joe Smith is the subject of the special condition, then Joe Smith can't post your bond. All right, I don't work for any bonding company, and I don't know or keep up with how they work. So the bonding company is the best source. A representative from the bonding company is your best source about percentage or fees or any of those things related to bond. Generally, it's about 15%. But again, I don't know, and I don't want to tell you something wrong, and then you speak to someone at the bonding company and they give you different information. So they know what the percentage is and all of that, and they will be the best source For those of you who will be posting bond through the bonding company, one thing that I must note that there is generally, if it's property, there has to be generally 3 times the bond amount. So if the bond is 1,000, the equity in the property has to be at least 3,000. And that's generally how it works with the bond. Again, speak with someone at the bonding company. They're your best source for all the details about bond. Also, for those of you who do not bond out of jail, listen closely. If you bond out of jail, this may not apply to you, but if you're still in jail, your next court date is your preliminary hearing. Again, you can waive it, or if you bond out of jail, it's automatically waived. Now, if you waive it, it doesn't mean you're giving up your presumption of innocence. It simply means you're just skipping that phase. All that's happening is you'll still be in magistrate court for your preliminary hearing, and that is a probable cause hearing, or prelim, as it's also known. All that means is the officer or officers have to testify as to the valid, articulable reason why they arrested you. They have to say, this is why I arrested this person. They have to say why they arrested you, and it has to be a legally valid reason. If it's not a legally valid reason, your case can be dismissed. If it is a valid legal reason, then your case can go to state court if it's a misdemeanor, or superior court if there's at least 1 felony. All right, and then your case leaves magistrate court and goes to state court or superior court. If you bond out of jail, again, that date goes away and you wait and stand by in the mail for your arraignment date. All right, if you're still in jail, you have your preliminary hearing, or again, you can waive it. So for those of you charged with misdemeanors, your preliminary hearing date is September 7th. For those of you charged with felonies, your preliminary hearing date is September 8th. If you don't get a bond, your bond hearing date is September 10th. All of these dates are subject to change because, again, once you speak with your lawyer, things can change. I can't give you legal advice. That's what your lawyer can do. So when I call you up individually, I will tell you what you're charged with, your bond, if you're entitled to a bond or you're getting a bond, your preliminary hearing date, whether you qualify for an attorney, court-appointed counsel, and I'll ask you if you have any questions related to those 4 things. And that will conclude your first appearance. I do have one individual on here, Megan Miller, on for a extradition matter. And we'll go ahead and proceed. Each of you raise your right hand. You solemnly swear or affirm any statements or testimony you will give in this first appearance matter not pending before the court shall be the truth, the whole truth, nothing but the truth, so help you God.
Yeah.
All right, thank you very much. And Deputy Cox, we're doing the ladies first. Gentlemen, be on standby for me. We'll see you in a minute.
Okay, first one is Ms. Cummings.
All right.
Come up here. So you put on the back.
Is that-
Hello.
Yes, Ms. Cummings, good morning to you, ma'am. All right, charge of 1 count of theft by taking, misdemeanor. 2,000 is your bond. 1 count of obstruction of a law enforcement officer is 1,000. It's your 3,000 total. September 7th at 8:30 is your preliminary hearing. And 1 moment here, Ms. Cummings. Ms. Cummings, you do qualify for a court-appointed attorney. I'm appointing one to represent you. You have any questions?
I have a family lawyer who's going to take over this.
Yes, ma'am. What's your lawyer's name?
My husband knows his name. He has the lawyer's information.
All right. So I'm appointing this attorney to represent you. Once the family lawyer comes on board, ma'am, that lawyer will then file a substitution of counsel and that person will represent you, okay? But in the meantime, you're gonna have a lawyer and then that lawyer will be replaced with your lawyer, okay?
Yes, sir.
Yes, ma'am, thank you.
Next is Ms. Dara. Your Honor, you have to speak up a little bit, kind of speak slow because she's hearing impaired.
Yes, sir, Deputy. Ms. Dara, can you hear me?
Yes.
Yes, ma'am. One count of obstruction, 1,000 is bond. One count of disorderly conduct, 1,500. September 7th at 8:30 is your prelim. And I did appoint an attorney to represent you. You have any questions?
Yeah, I did, I've been on like medication, but it's my first time doing all this stuff. And I was just, trying to get me and my fiance off the street. We're kind of like currently homeless right now. So my ability to send me money, I just don't remember everything I said yesterday because of my bipolar, so.
Well, yes, ma'am. That's as low as the bond can be, and hopefully your fiance can bond you out soon, or the deputies can get your medication if available.
Yes, I'm currently taking one, but when me and him were in a group home, she never got my depression anxiety medicine.
All right, you good?
Yes, ma'am. Thank you, Deputy.
Yes, ma'am. Next is Ms. Johnson.
All right.
Hey.
Hi, Ms. Johnson. Ma'am, you're charged with criminal trespass. 2,000 is your bond. Obstruction of an officer, 1,000. Possession of less than an ounce of marijuana is 1,500. Use of possession of a drug-related object is 500. And crossing the guard line is 1,000. 6,000 is your total. It's no contact with Sabrina Cade. And your preliminary hearing is the 8th of September, 8:30. Ma'am, you understand all you're charged with, the bonds and the special condition?
Yeah.
I am appointing an attorney to represent you. You have any questions?
So do I have to, I was told when I first came, I gotta pay 15% of my bond. Is that still that?
I'll go with that, ma'am. Go with that. All right. But when you speak with someone at the bonding company, they can tell if it's something different, they'll be able to let you know.
Okay.
Last is Ms. Miller.
All right.
This is the fugitive, Your Honor.
All right, Ms. Miller, how you doing this morning?
Good, how are you?
I'm doing pretty good here, ma'am. All the rights that I outlined, all those rights apply to you, ma'am, except that you're here for something a little bit different here. It's extradition matter. And you also are entitled to an attorney. As I mentioned, all those rights apply to you. And you're charged with being a fugitive from justice. The warrant reads that you did enter and remain in the state of Georgia knowing that you're wanted by the Clayton County Sheriff's Office in Florida for domestic battery, and it lists the warrant number. And Clayton County, Florida will extradite. So what that means, ma'am, is that today, this hearing is being conducted pursuant to the official code of Georgia annotated, that's OCGA Title 17, Chapter 13, specifically saying that you're charged with that offense in Clay County, Florida, and they will extradite. You have a choice this morning, ma'am, to waive or contest the extradition. You can be returned to Florida without going through the formal extradition process. If you decide to contest or fight the extradition, committed to the Clayton County Jail for 30 days, awaiting Governor Brian Kemp's signature. That's the governor of Georgia. His signature on a warrant. The court can consider bond, but I can tell you right now, Ms. Miller, there is no bond today based on the fact that you are indeed a fugitive, ma'am. Also, if you wish to voluntarily return, you can do so. If you wish to contest, there are 4 things that you can fight or contest. First, whether the extradition documents are in order on its face. That simply means the warrant I read and any related documents are legitimate. Secondly, whether you're charged with a crime that actually exists in the state of Florida. So for example, you know, marijuana would have been illegal somewhere, let's say in California, but now it's legal. So maybe similarly with this charge here in Florida. So if it's no longer a crime, then you can fight that and say, hey, it's no longer a crime. It was a crime. It's no longer a crime now. Third, whether you are in fact Megan Ursula Miller, you can contest whether you are the named person in this paperwork. And lastly, whether in fact you are a fugitive from justice. Maybe you received permission, maybe something else is going on. So those are the 4 things you can contest. So you're entitled to do so. You can't contest whether you are guilty or not guilty. That's for another proceeding or for trial. So those are the 4 things only that you can contest. All right. So if you contest, again, you can remain for the 30 days. And then, of course, they can be an extension for up to 90 days. In the Clayton County Jail, and at that time, if nothing has happened, then you can or may be released. If you waive extradition and voluntarily decide that you wish to have the state of Florida pick you up, Clay County, Florida, then, ma'am, you can remain in county for 10 days, and they will have that time period to come for you. Additionally, ma'am, there can be an extension sometimes for up to 30 days, but generally it's 10 business days, all right? If you waive. So have you understood everything I've said at this point, ma'am?
Yes, sir.
All right, Ms. Miller, do you wish to waive or contest?
Can I ask one question before I answer that?
Yes, ma'am.
Make sure that I completely understand. So waiving is allowing Clay County to come and pick me up.
Yes, ma'am.
Okay. So that's what I want to do. He froze.
Can you hear me?
Yeah, I can hear you now.
Ms. Miller, are you waiving at this time, ma'am?
Yes. He froze.
Yanni, your internet keep going in and out, Yanni.
All right, how about now? Can you hear me?
Yes,
All right, do you wish to waive at this point, Ms. Miller?
yes.
All right, I've sent over waiver of extradition forms there, some 7 of them. If you could sign off on each one of them, ma'am. And I believe you may have to fill the date in. For whatever reason, the date wasn't on there. So fill in the date and sign each of those for me, ma'am.
Okay.
All right, and after you do so, that will complete my discussion with you this morning, unless you have any additional questions.
One more other question. You said about the voluntary option to consent, voluntary. Could you explain that one?
Yes, ma'am. So you're waiving the fight. You're not going to contest or fight the extradition. You're voluntarily going back to Clay County, Florida. All right, so they'll come and pick you up. All right, and then you'll deal with the charge there in Clay, Florida. Seems like, did I freeze again on you, Ms. Miller?
Yeah, you did.
All right, I can see it happening. So what I'm saying is they'll come pick you up. Clay County will come pick you up, okay? and then you'll deal with the charge.
Same spot every time.
Get you. There's nothing else happening with us here in Florida, in Georgia. Because everything will be Florida.
Is that the same as me saying that I would like to waive?
Yes, ma'am. That's
Okay.
exactly it. Yes,
Okay.
ma'am.
Okay,
All right, that's it.
thank you.
All right, thank you, ma'am. All right,
Yeah.
Deputy Cox, so you got me on that, right? She's gonna fill that out and everything, so we're good.
Yes, sir. She already filled it out. I'm gonna fax it over to you.
All right, yeah, I don't need it. Since you could just turn it over to the clerks, because I signed it already, right? That's the one that I signed, the ones I signed.
No, sir. You didn't sign this one.
All right, so I sent over 7 of them that's already signed.
Okay.
All right, so for that very reason, so that way you don't have to send it back to me.
All right. Okay. I'll see if the clerks have them.
Okay, all right, appreciate it. Thank you, and thanks for that email earlier.
Yes, sir.
All right, thank you. All right, Mr. Butterfield, good morning to you, sir.
Good morning, Your Honor. This is my first appearance before this honorable court this year. How are you, Judge? Judge, did you hear me?
I'm sorry, Mr. Butterfield. I froze or you froze? How you
No,
doing?
you
Good morning to you.
You froze, Judge, but I won't
I
hold it
never
against you.
freeze.
This
I
is
never
my
freeze.
this is my first appearance before this honorable court this year, Judge. Good to see you on that bench.
Thank you very much. Just like you, so I'm not. It's not. It's been an interesting year, but good to see you as always. And how's everything going with you?
Everything is good, Judge. I can't complain at all. I'm here. I wasn't sure if we began at 11. I got conflicting information at the jail. I visited my client this morning, but I have Anthony Brett on your calendar whenever you reach it. BRETT.
Doing first. Yeah,
Okay,
we're doing
thank you.
first. So we do start at 11, but the deputies were courteous enough to send me a message that they were ready earlier. So
Okay.
we just got started, and we did the females. So we're on to the males now. So go ahead and get your client here. Deputy, who's on the male side this morning? How you doing, sir? Deputy, what's your name?
Deputy Alvarez.
All right, Deputy Alvarez, good to see you again here. We're gonna do Mr. Brett. We're gonna take him out first. Brett, Anthony Brett.
Yes, sir.
All right, Mr. Brett, good morning to you, sir. Can you hear me?
Good morning, y'all. You hear me?
Yes, sir. All right, so we have Mr. Taurus Butterfield here. Your attorney is on with us, sir. And you're charged with 1 count of use or possession of a drug-related object, 2 counts of violation of the Georgia Controlled Substances Act, the Schedule 1 controlled substance, that's MDMA or ecstasy, and ecstasy pills, as well as possession of marijuana and possession of a weapon during the commission of a crime. So I have some bond amounts that I had in mind, but I'll hear from counsel here before I make a final decision. Mr. Butterfield, you wish to be heard this morning, sir?
I do, Judge, and thank you very much. Judge, I know Mr. Brett's father actually does HVAC. I've been knowing his dad about 5 or 6 years or so, maybe more. And he called me late last night saying that his 19-year-old son had been arrested, and that is Mr. Anthony Brett Jr. I understand this young man was driving a car that was stopped for running a stop sign. He was in the car with his girlfriend. Classic case when the officer said he smelled marijuana. They searched a book bag. Well, actually, they asked him if he had any drugs or marijuana. And apparently, I think this is less than an ounce of marijuana, this ecstasy, and apparently his brother's gun was in the car. Judge, this man is 19 years old, and what I found out is he has his own home. Like, he literally, my 20-year-old son lives with me, but he has his own home. He works with FedEx. He's been working with FedEx for about a year, making about $16.50, and he graduated high school last year. Has his own car that's paid for. So it looks like everything prior to this arrest was going pretty good in his life. I mean, I was impressed with what he had done before, but now we got this situation, and I've explained to him he can lose it all. Having said that, Judge, we would ask that a reasonable bond be set on the drug-related objects, I understand was a digital scale that was in the door of his car, but I'm going to leave it in the court's discretion. His parents actually hired me on this matter, Judge, and partially retained me, but whatever you do in your wisdom, Judge, we would ask that you just take into consideration that he's 19 years old, and we do want to have a bond where he can try to get back to work. And it is our hope that down the road, we can put this matter behind him without it affecting his whole life, because I've told him he now has one jail in the prison and one on the outside. So that's where we are, Judge, and we thank you for hearing from us.
Yes, sir. Thank you, Mr. Butterfield. Mr. Brett, I just heard from counsel there. You have great counsel there in the form of Mr. Butterfield. And just based on what he's outlined to me, I'm going to reconsider what I initially had before speaking with him, and give you a slightly lower amount, knowing some of your background there. And this is not to be taken lightly. So I hope that you appreciate what's happening this morning here, sir. Based on the seriousness of the charges, or will be looked upon as very serious when the district attorney goes forward here. On the possession of the drug-related object, sir, is $500 is your bond. The violation of Georgia Controlled Substances Act, as it relates to that, would be $4,000. On the marijuana, that would be $2,000. And on the weapon charge, sir, that'd be $3,000. It's $9,500 is your total. All right, you have a preliminary hearing. The date is scheduled for the 8th of September.
Judge, I spoke with Mr. Brett about a prelim and waiving, and because the court has been kind enough to set a bond, we do believe he'll make that. So we're going to waive the prelim.
Yes, sir. All right, so that'll be waived. And thank you very much, Mr. Brett. No questions.
No questions. Nothing further from the defense, Your Honor.
Yes, sir. All right, Mr. Brett, thank you, sir. Mr. Butterfield, thank you, sir. You're excused. Good to see you.
It's a pleasure, Your Honor. I look forward to seeing you on the next time around. Keep up the good work, Judge. And Mr. Brett, I'll let your family know about the bond, and thank you, Judge.
Yes, sir. You're welcome. Thank you. See you
All right,
next
have a great day.
You too. Yes, sir. Good morning. Who are you?
Jarvis Billingsley.
All right, Mr. Billingsby. Good morning to you, sir. All right, sir. You're charged with one count of public transportation token ticket, certain acts in the public transit. It's a $1,000 bond. And you have a preliminary hearing date of September 7th, 8:30. And I did appoint an attorney to represent you. You have any questions, Mr.
Is it possible I can get a signature on or
Billingsley, sir?
Yes, sir.
You have any questions?
Is it possible that one could retrieve a signature or bond being that I'm unemployed and don't have the funds? And I'm expecting to get a job before September 7th to get out.
Sir, that's as low as it can go today, sir.
All right, well, thank you.
Thank you.
Good morning, Your Honor. My name is Tyrone Coleman.
Yes, sir. Good morning, Mr. Coleman. You have one count of battery, and there's a $5,000 bond. There's no contact with it's scheduled for September 7th.
I'm sorry, Your Honor.
And attorney to represent you. Can you hear me?
Screen had froze up. I didn't hear the name you said. I'm sorry.
All right, 5,000 is your bond, and it's no contact with Henry Wade. September 7th, 8:30 is your preliminary hearing. And I did appoint an attorney to represent you. You have any questions?
Could the bond be lower than that?
5,000 is your bond, sir.
Thank you.
Thank you, sir.
Davis, this one.
All right, Mr. Davis, you have one count of criminal trespass, damage to properties, 2,500. No contact with Arizona Weathers. You understand what you're charged with in the bond amount and special conditions, sir?
Yes, sir.
All right, you have a preliminary hearing. That is scheduled for the 8th of September, 8:30.
Okay.
I did appoint an attorney to represent you. You have any questions?
So 2,500 the bond?
Yes, sir.
Real one, ain't better no lower than that?
No, sir.
Good morning, Judge.
Good morning, sir.
Morning, favor.
All right, Mr. Favors, one count of obstructing an officer is 1,000 is your bond. One count of open containers, 500, 1,500 is your total, sir. September 7th at 8:30, that's your preliminary hearing. And Mr. Favors, I am appointing an attorney to represent you. You have any questions?
No, sir.
All right, thank you, sir.
The Green.
All right, Mr. Green, good morning. All right, misdemeanor marijuana, less than announced, 1,500, and stop sign violation, 500. 2,000 is your total. September 7th at 8:30 is your preliminary hearing. And I did appoint an attorney to represent you, sir. You have any questions? No questions. Thank you.
Johnson Taylor.
All right. What's your name? What's your name?
Hey, Johnson.
What's your last name?
Kamara.
Kamara. All right. All right, Mr. Kamara. One count of loitering or prowling. Misdemeanor, 1,000 is your bond. You can't go back to 6063 West Fayetteville Road, Clayton County, sir. You understand what you're charged with, bond conditions?
Loitering, that's it.
Yes, sir. Just loitering and prowling, the one count.
Yes, sir.
All right. And I did appoint an attorney to represent you, sir. You have any questions? All right, thank you.
Neely Antonio.
Good morning, Judge.
Good morning. One moment here. What's your... All right, let me just double check here, Deputy. So Elijah Abdullah bonded out?
Yes, Your Honor, he's OTB.
OTB. All right, thank you. Just making sure. One second, Mr. Neely. One moment here. Sorry, just double checking Mr. Neal's paperwork here. All right, Mr. Neely. Thank you for your patience there, sir. All right, it's one count of failure to have headlights on is 500, and then one count of possession of marijuana. They never said the amount in the warrant.
Yeah, can I say this, sir? It was, she was advised by her lieutenant and sergeant that it was less than an ounce, but when we got to the judge, she never put it down.
Yeah, all right, yeah, they never put the amount, so I'm gonna make it less than an ounce, make 1,500, okay? 1,500 plus the 500, it's a total of 2,000 is your bond, sir.
Thank you, sir.
All right, and your prelim is set for the 7th of September, 8:30. And lastly, I am appointing an attorney to represent you.
All right, you have a good day.
You too, sir. Thank you.
Stanley, Tyson.
How you doing, sir? What's your name? Who are you? All right, Mr. Stanley. You're charged with one count of possession of a weapon during the commission of a crime. Your bond is 3,500. Possession of less than an ounce of marijuana, that is 2,000. 5,500 is your bond. Preliminary hearing is scheduled for the 8th of September, 8:30.
Okay.
And lastly, sir, I am appointing an attorney to represent you. You have any questions?
No.
All right, thank you.
Carol Gillen.
All right, sir. Good morning. You're charged with one count of obstructing an officer is 1,000. And then one count of theft by taking a motor vehicle, that's a felony, 5,000. 6,000 is your total bond, sir. Preliminary hearing is scheduled for the 8th of September at 8:30. And I am appointing an attorney to represent you. All right, you have any questions? All right, thank you, sir.
Wilson Wendell.
Randall Wilson, how you doing, sir?
All right, good morning, Mr. Wilson. I'm good here. Sir, you're charged with one count of criminal trespass. Your bond is 2,000 on that offense. Unfortunately, on the aggravated stalking, the felony, there's no bond today, sir. You do have a preliminary hearing. It's scheduled for September 8th, and that's at 8:30. Your bond hearing is September 10th at 8:30. Sir, once you speak with the lawyer, I'm appointing an attorney to represent you. Speak with that lawyer, sir, and you may be able to get a bond before that September 10th date. You understand what I've outlined to you, sir?
Yes.
All right, and Mr. Wilson, you have any questions?
No, I don't.
All right, thank you, sir.
White Willie.
Morning, Judge.
Good morning, Mr. White. All right, sir, you have two counts here, criminal trespass. Your bond is 2,000. Less than an ounce of marijuana is 1,500. 3,500. Special condition, no contact with Rashida Robinson. And preliminary hearings, September 7th, 30. And I am appointing an attorney to represent you. Yeah, questions, Mr. White?
Yes, I'm sorry, I kind of cut off. What's the total amount again? I'm sorry.
Yes, sir, 3,500.
Okay, thank you.
All right, thank you, sir.
That was the last one, Your Honor.
Yes, sir. All right, Deputy, thank you very much. See you next time.